Okay, welcome everybody. For those of you who don't know me, I'm Jonathan Zeitlin. I'm a professor of public policy and governance here at the University of Amsterdam. I'm also the director of the Amsterdam Center for European Studies, ACES, and a member of the Amsterdam Center for European Law and Governance, which together are sponsoring this roundtable. So we have a book launch roundtable on this new-ish book by Yane Svetiev, Experimentalist Competition Law and the Regulation of Markets. I'm delighted to welcome Yane back to Amsterdam. He's been a regular visitor over the years, not only to ACES and ACELG, but also to Access Europe. Before that, he's come a little further since he's now based at the University of Sydney in Australia, although he is also a Fernand Braudel fellow at the European University Institute in Florence. And before that, he's taught at Bocconi University and had appointments at the EUI and Brooklyn Law School. It's really a pleasure to bring Yane here for this to discuss his book, having met him first when he was an SJD student with Chuck Sable at Columbia, and had the pleasure of having him contribute to edited volumes on experimentalist governance. We have a distinguished group of discussants, and I'll introduce them in the order they're going to speak. First, Rupprecht Podszun. He's vice president of ASCOLA, the Academic Society for Competition Law, and he's chair of civil law, German and European competition law at the University of Düsseldorf, and also an affiliated fellow at the Max Planck Institute for Innovation and Competition in Munich. Our second speaker will be Siún, I got that right? Siún, excuse me, O'Keefe, who is now the manager of the ACES Academy attached to the Netherlands Authority for Consumers and Markets in The Hague, where she was previously senior strategy advisor. Many of us have had the pleasure of interacting with her in that role. The next speaker will be Paul Nihoul, who is a judge at the General Court of the EU. He's a former president of ASCOLA, and he's a graduate from Harvard University and the University Catholique de Louvain. And finally, last but by no means least, Paul Lugard is a partner at Baker Botts in Brussels and past chair of the ICC Competition Commission. So he's a practicing EU and international competition lawyer. His practice focuses on complex merger review proceedings and investigations into alleged, I guess one has to say that, anti-competitive business practices, especially in high-tech areas. So the format is that
I'm sorry, but you're muted for everyone.
Yep.
Yeah, you were muted for 10 seconds.
okay, people have heard me. I don't have to go over this again. Okay, so then Yane will reply briefly to the discussants, and then we'll open it up to Q&A with you, the audience, and other people in the room. There are also other colleagues around the room sitting with us in this hybrid session. And I will encourage you when it's your turn to speak. Okay, Rupprecht is not hearing us. Why is he not hearing us? Can anybody else hear us? Put your hand up.
I'm with you, Jonathan. I hear you. I see you. I'm here.
Good. Okay, sorry. I just saw this chat message, maybe it was lagging. I do apologize if I'm repeating myself here. And then I'll just encourage you to put your your virtual hands up. I will be able to see you in the participants list, which we have up on the screen. And then I will, if your connection is up to it, I'll encourage you to speak, to put your microphone on, your camera on, and I'll give you the floor. Okay, so Yane, why don't you kick off?
Okay, thank you very much. I'm very, very happy to be here at the University of Amsterdam, and I want to particularly thank Kathy, Jan, and Jonathan for the initiative and for organizing the event. Since the book was published mid-pandemic, there have been a few opportunities to discuss the arguments all online. But at least now we're in, back in the room, at least some of us, and in hybrid format. So I hope that this, marks a return to normal, and that I will also have a chance to see many of the online participants in person in the coming months. Now, I also should say that I'm particularly honored to have as commentators and discussants a number of people for whom I have great esteem. They're both scholars and practitioners, and some of them are both, and they've all made very significant contributions to the scholarship and practice of competition law and market regulation. Based on the somewhat wonky title, you might kind of wonder you might think, I suppose, that this idea of an experimentalist competition law is a largely conceptual idea. In the book itself, I don't necessarily claim that competition law and market regulation in the EU are fully fledged realizations of an experimentalist governance. But what I try to do is to actually offer a mirror on current practice, ranging from enforcement authorities like the Commission or national authorities, as well as to practitioners and to courts. What I try to argue is that many of the developments in the enforcement of competition law over the past decade or so can be understood through an experimentalist lens. And I also try to provide some guidance on how the institutional and the remedial arrangements that I discuss can be, in a way, completed, if you want, from an experimentalist point of view. And so, to summarize, perhaps, the normative argument is that the experimentalist competition law as a tool of market regulation is both feasible and desirable, as a matter of description, it can also be detected in current practice. But all of the claims that I make, both the positive and the normative, can of course be contested, and I have in fact invited the discussants in the roundtable to offer, hopefully some praise, but also criticism to the ideas and arguments presented. Now, on the assumption that many of you have not had a chance to read the book, I just want to present a few background themes. I probably have, more prepared than, the time that's allowed to me, but Jonathan will give me a sign to kind of, to wrap up, and I'll do that, and then any of the other stuff can possibly come out in discussion.
So I'll let you know when 5 minutes have passed.
Okay.
So I think that's where we're getting.
Okay. So many of you may be wondering, if you haven't read the book, about what experimentalist competition law is. I have found it useful in other contexts in order to explain what it is, to also start by explaining what it's not. And so I should emphasize that this book is not about behavioral antitrust that incorporate behavior to formulate goals, instruments, and our analytical categories for competition enforcement. This kind of experimental evidence could play some role, but it is neither essential or even central in the kind of experimentalist governance that I'm talking about in the book and that we have worked on together with Jonathan and other colleagues. And in the conclusion of the book, to the extent that some might find it useful, I try to distinguish different notions of experimentalism in the context of regulation to make some of these ideas more plastic and to enable kind of comparisons and distinctions to be made. Now, I think this point is also important because some of the more recent legislative initiatives in the digital market space, which we may get to discuss later, seem to more explicitly incorporate certain experimentalist approaches. And it may be important to be sensitive to these distinctions in trying to assess the extent to which things like the regulation of gatekeepers and algorithms that has been proposed may in fact present an experimentalist institutional design. Now, the notion of experimentalism used in the book relates to a regulatory architecture that responds to two conditions that affect modern regulation more broadly. One being radical uncertainty about how to select the implementation mechanisms to achieve specified public interest objectives, and the second being polyarchy, whereby a particular regulatory actor does not have the power to impose their own preferred solution onto the others. And one possible response to these conditions is to specify or identify a set of common regulatory goals that all actors are pursuing, to give lower level actors some discretion to select appropriate instruments through which to pursue those in their local context, but subject those implementation efforts to review by peers. And in light of such review, we can proceed to revise the individual implementation exercises or even the commonly identified goals of the regulatory regime. So these are, in very broad brushstrokes, the key functional components of an experimentalist governance architecture for those who are not familiar. And you can see why it is sometimes said that experimentalist governance is about coping with uncertainty by learning from experience, including diverse implementation experience rather than from experiments. You could also see, for the EU scholars among us, why the EU has been a fertile ground for exploring the emergence of this governance paradigm. Now, during my first presentation about the book, after it was published, which was organized within ASCOLA, I thought that my first important task would be to convince the audience that the two scope conditions, uncertainty and polyarchy, are relevant to competition law and market regulation. Now, having been back in Europe for a couple of months now and followed this, where the debate has been moving, at least since the beginning of last year, and in the digital market space, I think that my task is somewhat easier because a number of developments appear to have brought about a quite widespread appreciation of the radical uncertainty problem that's besetting competition enforcement in the contemporary context. So first, the problem of dealing with the digital gatekeepers, to use the newly fashionable term, has brought about an appreciation of the uncertainty that we face even at the conceptual level, in terms of what kind of market rivalry we seek to promote through competition enforcement and for what public interest purpose. I suspect that all of us present in this room, this hybrid room, would probably agree that some market rivalry is good from the public interest perspective, but once we go beyond that statement to seek further specificity, either about what market rivalry is or how much rivalry is sufficient and for what benefits, there will be disagreements based on observed outcomes rather than merely on ideology. Now, second, again, in the digital market space, we see that these markets have laid bare the shortcomings of the more economic tools that have been used to aid antitrust decision-making by modeling in order to predict future market effects, even if we were to agree on a sort of narrow conception of the objects of antitrust as being something like allocative efficiency. And this seems to be a part of a broader crisis of expert knowledge, whereby we seek to narrow regulatory goals in ways that are susceptible to technocratic analysis. in a way that tends to ignore the interaction of competition interventions with other goals of public policy. And again, this has been brought into sharp relief by questions about dealing with sustainability or even cultural or way of life objectives in antitrust decision making. Now,
you're running towards the end of your time.
yeah, that's fine.
Yeah.
I'll
Wind up a little bit.
Again, the uncertainties about dealing with the personal data collection and privacy in digital markets or the analysis of sustainability initiatives, seems to have, revealed the failure of a key premise that keeps antitrust enforcers asleep at night, which is the idea that if we simply focus on maintaining competition in markets, and that we should simply focus on maintaining competition in markets, and that if competition cannot deliver outcomes consistent with the public interest, there's always some form of ex ante public regulation that we can resort to. Now, as the Dutch ACM, among others, has found out, this kind of siloed view of regulating markets is not particularly helpful, because any public regulation effort itself will have to solve the problems of uncertainty and coordination, and often regulation, which is not fit for purpose of attaining its designated goals. So maybe in light of Jonathan's encouragement, I'll stop here by pointing out that experimentalist governance precisely tries to essentially elide the distinction between ex ante regulation and ex post enforcement through an iterative approach to both formulating remedies and rulemaking. And that might be enough by way of introduction, and we can pick up some more of the themes in the discussion.
Okay, thanks very much, Jana. And the book, as I'm sure the commentators will underline, is extremely rich and full of examples and in-depth analysis. So if your appetite is whetted by these remarks to understand better what Jan is saying, you have no choice but to read the book. Okay, without further ado, I'm going to go to our first discussant. Rupprecht, you have the virtual floor for the next 7, max 10 minutes.
Thank you so much, Jonathan, and thank you, Jana. As you just said, Jonathan, since Jana is far too modest to say anything like that, buy the book, read it, and analyze it, and go through it. And if you have not yet done so, it's worth it. I can assure you. Now for the critical part. No, not yet. When I heard that Jana is writing a book on experimental antitrust, I was shocked and I was thrilled. I was shocked because I thought this is exactly the book that I want to write all the time. But then I'm just a law professor doing administrative stuff, so I never find the time anyway. So it's perfect if you have someone who is much younger than I am, much more energetic, and who does it in a far better way than I could ever do it. So I'm thankful now, after coming over that shock that the book is now written. I'm thankful, Jana, that you did it, because you did it way better than I could have ever achieved it. And I'm very grateful and thankful for the inspiration you provide me with. I was thrilled, and that topic thrills me because, I mean, if we look at it, I think it is the most fundamental clash that we can imagine. All of us doing law are in a business of providing stability, certainty, of dealing with rules that have come to us 50 years ago, 100 years ago, or something like that. So so we are actually in the business of being conservative. It just does not only show in the clothes we wear, it shows in our mindset. We are dealing with conservatism, we are dealing with stabilizing, with providing legal certainty. I mean, how many times do I tell my students, companies need legal certainty? It's very important that they know what they have to do. And now there's Yane Svetiev coming telling us, oh, this is just an experiment. And this is what thrills me in this topic. And I'm so grateful, Jana, that you picked that up and gave that such a good, the book that you have to read on this. Now, looking at this clash of stability on the one hand and experimenting on the other hand, I think that one of the vital questions and one of the very interesting questions is what is the role of the courts in this, because we know that laws and rules as we provide, as legislators provide them, are rules that are sort of coming from a very difficult procedural regime, etc. And we know, okay, they put that into laws, but then we have the courts to adapt and to adjust and to sort of experiment with what's happening. Or, I mean, first it's of course the lawyers like Paul Lugard, and then it's the other Paul, that's Paul Nihoul, looking at it from a legal perspective. And what strikes me is, and you have a full chapter dedicated on that, Yane, is that you deal with the courts as potential catalysts for change, and catalysts, that's the term you use, as catalysts for experiment. And at the same time, at present, we are looking at what the European Court of Justice does, and our feeling, I hope Paul Nihoul is listening and can sort of rebut of what I'm saying, our feeling is that the Court of Justice is maybe standing in the way of, okay. I know you are not the typical judge, Paul, but you can say a word on that yourself. Now we find, or my feeling sort of is that the Court of Justice is maybe standing in the way of a more progressive, more experimentalist antitrust rule. And I wonder, and maybe Yane, you can elaborate a bit on that, what your feeling is, how do we make these courts a bit more progressive, a bit more experimentalist, a bit more trying to find this catalyst role that you assign to them in the current sort of handling of cases? I mean, if we look at the Google proceedings, for instance, our fear, or the fear of more progressive antitrust people, if I may say so, you may call them antitrust hipsters, our feeling is that maybe the court will stop all that. And maybe, or one of the values of the book, I think, is that Yane encourages rule makers to experiment, and encourages also to sort of say that they are innovative, that they are experimenting. And this is something that I feel is lacking in the Commission's decisions on Google and in other decisions that we currently see, where we are not saying, okay, see people, this is a new time, we are doing something completely new, we are having companies that we have never seen before, we have to experiment. I think the Commission always, and maybe that's a topic also for Siún, to comment from the Dutch perspective, the agencies very strongly try to remain in the mainstream, remain in what has been said before, instead of assuming this role of being experimenters. And maybe, Yane, we can work on that, on pushing them to do that a bit more actively. A second notion, a second thing that I would want to put forward is, if you've talked now also in your introductory statement here a bit about experimentalism as a governance theory, and I wonder, that is something that I've always grappled with, and to be frank, I think there may be something in the book, maybe I've missed it, but one point that I would love to read more or know more about is, how can we make use of scientific experimentalism in the law? And in scientific experiments, say if you're working in chemistry, in biology, etc., what we usually do when we do experiments is, we have different groups. We have a control group, we have an experimental group, we try to control certain variables, etc. And I would love to see this more in the law, in the sense of, let's find out how we can work with control groups. Is that even lawful if we say, okay, we only apply these rules now to the Italian, the French, and the Spanish people, and the rest of Europe takes the old rule, and then we see what happens, or something like that? I mean, we think of Europe as a laboratory often in this regard, but maybe we can learn a bit more about how you imagine this process taking from the lab, from the science lab to the law lab, this point. I still have 2 minutes left, Jonathan, I hope. So let me...
2 minutes would be perfect.
Okay, let me make two brief other points. The one is, one further point, there are two cases that you dwell on at length, and that are sort of evidence for experimentalism. That's the German Facebook case and the German Booking.com case, the MFN case. And I love these cases. And when I read that, and I thought, and you also quote Andreas Mund, the president of the German Competition Authority, on that, speaking in favor of an experimentalist governance structure. And I wonder, why is it that these German cases are sort of features of experimenting? It is because the German competition watchdog steps away from the European Commission's sort of main approach and says, okay, here we are, we take our own route. And maybe that is something for you to comment on, maybe also for Siún from the Dutch authority. So what is the stubbornness, what is the self-confidence maybe that competition agencies need in order to be pro-experimentalist? And then obviously the next question is, would we really be so happy if we had 27 agencies and national agencies coming up with different solutions? I would love to see that because I'm a big fan of experimenting, but I wonder whether that would not sort of overburden companies and the coordination mechanisms that you put forward and that you rightly address. The final point, you've already commented on the Digital Markets Act, and I can only compliment you and say yes. This is something where we step away, in my view, a bit from an experimentalist regulatory tool in that we try to do the self-executing Article 5 rules in the DMA, because they are very fixed. We don't have a general clause at present in the DMA. So that is something where we are stopping experiments because we want legal certainty, because we want quick timing. And I find that a bit problematic because I think these routes are not yet thought through completely, so it's difficult to experiment with them. And if we want to experiment with that, that's my final plea, and I know you are fully, I guess you're fully in line with me here, Yane, is we need to involve national agencies so that there are other actors coming into play with the European Commission, and we need to, and I love that part about in your book, we need to strengthen private enforcement in stopping infringements, not just for damages claims, but also for elaborating the rules. This is a point you make very strongly in your book. So we may need that as well in the DMA, an institutional setting that even in the narrow boundaries of the DMA allows us to experiment a bit by putting in other actors, other institutions than just the European Commission handling this act, which is very detailed in what it says. I leave it at this. I thank you, Yane, for first inviting me, but also for sharing these thoughts with us. They are so inspiring. I could go on talking for ages, but I guess Jonathan is cutting me off now anyway. So I leave it at this. Thank you a lot.
I'm sure you'll have another chance to come back in. Rupprecht, you've given us and Yane a number of interesting questions to think about the relationship between experimentalist governance and scientific experimentation. I would say there's also the question of whether fixed or bright line rules really provide legal certainty, or whether making explicit how rules are applied differently in different circumstances may actually give better guidance to companies. How much discretion or independent initiative in a network system of regulation in a single market is really workable. And on that kind of question, I think it's perfect to turn to Siún as somebody representing indeed a competition, a national competition authority.
Thank you very much. Well, let me start too by being complimentary, because I really liked the book and I'm delighted to be here today to discuss it with you. Yeah, Jane's book is very interesting if you're working in an authority, and particularly if you're working in the authority that he takes lots of his examples from. That makes it all the more interesting. And it's easy to read and, you know, just enjoyable. And it also, the term catalyst has been used here in reference to the courts, but these sort of ideas, it's very important that they're shared, because they can lead us in all sorts of different directions that we haven't even thought of yet. So I think it's a very valuable contribution to the literature and experimentalism, but also actually just on institutional design even. There's some lovely gems in there. So thank you for sharing it with us, for all your work. Rupprecht just asked a question, so I think I could address that straight away. You said, you know, what is the self-confidence that agencies need to be more experimental? And then you answered the question by saying it might be undesirable from the perspective of the firms. And that's one thing I really felt throughout this book. Every time there was a reference to experimentalist aspects of our work, or of the work of the courts, I thought, but you know, we're hugely constrained by certain parameters, and they mostly have to do with things like a rule of law and legal certainty, and confidentiality of firms' behavior. I mean, as an authority, we're extremely limited in terms of the discussion that we can hold. Everything we publish, we check beforehand. If we mention, you know, the firm's names, then the firm is contacted beforehand and they have a chance to object to whatever it is we publish. And it's not just that. It's not just that we are restrained in terms of being aware of their right to confidentiality and of the value of data, but it's also important in terms of retaining our integrity as an authority, or our authority as an authority. So confidentiality of information is very important. And to what extent a lot of the stuff that you know, would like us to do in terms of exploring various different solutions for problems require an awful lot of information. And certainly the discussion of them with third parties would require a lot of information. So some of the stuff I was reading in the book, I was thinking, oh, it would be nice if you had a little safe space, if you had a bubble that you could do this in. And in a way, we try to create that, because sometimes in our decisions, if we have something that's particularly tricky or an economic analysis that we think is new, we will invite a third party in a safe bubble to discuss it with us. But that's a huge constraining factor that I couldn't actually see my way around in what I was reading in the book. So that's one thing, is the confidentiality that the firms require. And as I said, that we require to show our respect. I couldn't help actually thinking about the situation in university. You know, I was thinking in a university, you have a PhD defense of their thesis, and somebody stands there and they defend it. And I'm sure that sometimes PhDs aren't awarded, but I'd say mostly they are. In fact, any defense I've been to, they have been. And that's because, you know, you see the need. You've got a continuing relationship with the person who's there and all the other people who are present. And it's not worthwhile really taking them down on the spot. It's better to have discussed all the failings beforehand and make sure it doesn't get very far.
Indeed, as you probably realize, the thesis only proceeds to defense if all but one of the 5 examiners have agreed that it's ready to go to defense. So you're going to fail. That's the point where you fail.
Yes. But you know, I couldn't help sort of seeing an analogy with some of the suggestions for using experimentalism in the decisions that we make me think of that situation. You know, I was thinking, how would it be if you had to defend every grade you give? You may not actually even support the grading system of 1 to 10. You might not think it's great, but it would not be very comfortable, normatively desirable, certainly not feasible to defend every single grade. Besides which, after the first 3 times, the only ones who would show up would be the student and his mom, maybe, you know, and they would have a particular perspective on the grade you give. But in terms of you know, normatively suitable and practically feasible costs, those were the obstructions that came to mind. Then maybe specifically, I thought the stuff on commitments was very interesting, chapter 2, and what you had to say about commitments. And to what degree, you know, we subject commitments to judicial review. And I know Cathy had a student this year who did a master's thesis on that topic, and it's one, you know, of great interest. The precedent value that is created by publication is something that we're very aware of and very keen on, and yet you have your restrictions in terms of the confidentiality of what you can publish. But I do have a little bit of difficulty with the concept of commitment as a negotiated settlement, because firstly, in terms of negotiation, for me, negotiation implies an equality of arms, and I don't think you have that in a commitment decision, because the parties are not equal in the sense that 2 private parties would be in a negotiation, because one party is the state effectively, and is in a hierarchical relationship at that point vis-a-vis the undertaking. And it doesn't necessarily mean that the authority is in a stronger position. In fact, in a way, it's in a weaker position, because, you know, the undertaking concerned doesn't have to be completely open. If we make a mistake, they're under no obligation to tell us that we've made a mistake. Whereas if they make a mistake, we have to tell them. We can't trick them And even if we wanted to, well, it would be dangerous anyway, because then again, you would lose your authority if you do that, you know. And I think in terms of your ability to choose an instrument, the cases in which you can use commitments are limited, and you actually point this out in the book. You know, you say it's unsuitable for certain types of infringements, but also, you know, and even to say that it's a settlement, I think it's not really a settlement in the sense that whatever is put on the table by the undertaking concerned has to be better than continuing the investigation and proceeding with the say a pecuniary penalty. So whatever is offered has to be something that is so effective and efficient that it renders the option of continuing as undesirable. So you're in that sense, as an authority, you're not really settling. And I'm not sure really that it's a proper negotiation either. And then a lot of what you said in terms of experimentalism is based on the facts of it being a sort of a negotiated remedy. And as I said, I don't really see it as that being that. So yeah, basically, where I like experimentalism particularly is, I think, when it comes to formulating policy, which officially we don't do as an authority, and probably practically certainly have an influence on it. And there, I think that's where experimentalism really shows its value, to create a safe space, creating sandboxes where policy can be developed in as open a manner as possible, can be effectively monitored. It was interesting what Rupprecht referred to about, you know, seeing experimentalism on the European level, where you can have different rules in different states. You know, we actually sort of had that with the hotel booking case, which is one of the examples you use. You had that situation where you genuinely had different rules in different states, and you know, the Commission then went and looked and tried to analyze together with member states to look at the effect of that. So that does happen sometimes. I think it happens more accidentally than deliberately, and having an experimental system would be sort of designing that to happen. I think from the perspective of the firms, they would choose for as much certainty as possible, as much convergence as possible.
Thanks, Siún. Definitely a number of key themes for discussion. One being around how we understand commitment decisions, commitment proceedings. I think a lot of people who study negotiations are very surprised to hear that they depend on equality among the parties. Differences in the meat of many analyses of negotiations in the social sciences, but you know, how we assess different under conditions of uncertainty, we don't know how they will play out. We want to discuss. And then the question again, what is regulatory, what is legal certainty under conditions which are changing, where you don't know what the consequences of applying a fixed rule may be. That I will let Yane respond in more detail. Okay, so we've had an academic, we've had somebody from a national regulatory authority, now we have a judge, and finally we'll have a competition specialist from practice. So I think that's a perfect mix of roles. And Paul and Nihoul, over to you, 7 to 10 minutes, please.
Thank you so much. Thank you also for the book.
We can't hear you very well. I would say turn up your volume and move closer to the microphone.
Can you hear me better now? Is that okay? Yes?
Can we raise?
Okay, so I'll speak loudly. All right. So thank you so much for this opportunity to read and discuss the book. I'd like to make 3 categories of comments, if you wouldn't mind. The first one on the current state of competition law. I think I can agree with you to the extent you say that the current state is not always and not often perceived by people on markets, at least this is what we hear, as being really enforceable when it is based on effect-based theories. It requires very long economic discussions and a lot of time. Plaintiffs, for instance, have to invest lots of money into this, the commission as well. So it's not really enforceable, that's what we hear. It's unadapted to the extent that the time which is necessary for authorities to take decisions and for courts to intervene does not correspond to market expectations. And third, it's not accepted either, because particularly as regards the intervention of courts, because the feeling is that when courts refrain their, let's say, propensity to control, there is a criticism that they do not do enough. And when they go beyond, there is this critique that they are being activists. So I understand, you know, your book is coming at the right moment to that extent, because there is indeed a need to come forward with a new solution. Now, do I accept what you say concerning the current state of affairs for what courts in the European Union currently do? I'm not sure. Page 128, 5, 6, 7, 8, you say that courts in fact limits its control to substantive aspects of the case, and try to concentrate on the errors of law and on procedural problems. You cite Chalcor, which goes beyond, and you're right, because at least the general court now, because it's his task, is going much farther than this. And it is actually very much in the line of what you propose as being a dialogic procedure, whereby there is a discussion between the authorities and the courts, which go beyond the errors of laws and procedural matters, but also as far as the assessments are concerned. In competition law, in fact, we pretty much see what you have described as being used in Pfizer 139, relating this animal substance, this chemical substance relating to animals. And you're presenting this as being kind of an example of what experimentalism could be in competition law. But it's, to me, it would appear that it's pretty much what is happening now in Luxembourg, in fact. When you look at Intel, it's not very different. What the Court of Justice said at the end is, talking to us, General Court, you should have gone further in the dialogue between, on the one hand, the company, and on the other hand, the commission, in order to try to see whether or not ultimately there was an unacceptable effect for the practice. So I think you may underestimate a little bit the point where we are at in Luxembourg. And I'm not trying to market our interventions. I'm really trying to describe it. Now, second chapter, if you want. I feel your approach is extremely interesting, talking about radical uncertainty on the one hand and polyarchy on the other hand, as being features of markets and of realities in general. And you're trying to, particularly polyarchy, you're trying to address this, or people working in the experimentalist attempts, I would say, are trying to address this polyarchy by subsidiarity. Very interesting, because subsidiarity normally allows a clear perception of what the problems are and what the solutions can be. And also by a kind of, yes, mainly subsidiarity, I would say. And also network governance, having, you know, several authorities deciding, and then a central clearinghouse. Very interesting. Then you talk about uncertainty, and what experimentalism proposes in order to deal with uncertainty is to reduce that degree of uncertainty by, among others, this recursivity thing. That is, try to see what is happening after the decisions. And indeed, if we are more acquainted what the consequences of our decisions are, normally we should be able to integrate this new knowledge in the future decisions that we will be taking. This is the central point, in fact. This completely lacks. There is nothing about this. No study has ever been done about the consequences of a judgment whatsoever. I'm not sure there are many consequences being done about the decisions taken by the Commission in some markets. But the question is, can we do that? And who is going to do that? So I'd like maybe in the discussion to have some ideas from you in that regard. Now, what I also want to, being a researcher before being a judge, in fact, I had the feeling I could trace the origin of experimentalism with, on the one hand, the political science theories of network governance. That is, it's much better if we decide together. Power has to be divided. There is no hierarchy. There shouldn't be any hierarchy, on the one hand. And on the other hand, this idea that science is based on experiments. That is, truth only comes through a process whereby we're trying to systematically, like Popper said, to invalidate the result. And so it's a process, whereas a court decision or a decision by an authority has to come at some point. I mean, there must be a point where we stop the process. So if I understand correctly, this genesis for experimentalism is extremely interesting because it tries to brings into law major developments which have occurred in science, hard science most of the time, as well as in political sciences for network governance. But I'd like to ask you, and it's in echo to what Rupprecht said earlier, there is a third element, I think. And the third element is maybe relating not to network governance, but to democracy. What do markets need and what do markets want? Are we going to establish or to develop a theory about how to apply competition law without knowing what firms need? And the answer which I receive as a researcher and as a judge when I'm talking to practitioners, and Paul will have a chance to tell us about that, is we need certainty, as the previous speaker was saying. We need certainty. Be it bad or be it good, it's better to have certainty than uncertainty. So the real question, and it's an epistemological question, is, to me, can the methods and the spirit and the essence of science, hard sciences in particular, be introduced into law? Does that make sense? Or is that completely opposed to one another and we have to dissociate completely? And, you know, about this radical uncertainty, very interesting question. You say it's a main aspect of current reality. Is it? I'd like to ask you the question. Uncertainty exists in competition law since we have been asking the question, what is the future going to be like if we take that decision? That is, once we have been introducing more and more economics into the decision. Beforehand, it doesn't mean it was better, but beforehand, we didn't have this uncertainty. I mean, we were applying a rule, and as we would apply a civil rule, like between two neighbors, one constructing a building without the consent of the other one, and we were not trying to understand what would be better for the area, for the city, for the world, you know, if we were adopting this decision or that decision or the third decision. So uncertainty something which is given or something that we have created ourselves? Now, let me see if I have still a last. Yes, but that's a suggestion for the future, very shortly. An area where experimentalism would be very interesting is the judicial architecture in Europe, with the national courts everywhere on the European territory, working in network governance, and how we would be able to organize all this in an experimentalist perspective. Just if you want to continue in that direction, that would be interesting for us to see what you think about that. Maybe I exceeded my time. Sorry about that, Jonathan.
Yeah, thanks very much. Lots of interesting ideas there. Among other things, you seem to be taking perhaps what we could call a Molierian position that the European competition enforcement is already substantially experimentalist, that Jordan are already speaking experimentalist prose, but also you're asking, what is really uncertainty? To what extent is it an artifact of the decisions or the competition law itself, as opposed to the environment? And there's some interesting questions also about to what extent and in what form we do have ex post monitoring and evaluation in the competition field. There are other questions also, but those are some that leave out very stimulating remarks. So finally, I want to give the floor to Paul Lugard, who I assume will give the perspective of somebody working in competition practice.
Thank you, Jonathan, and Yane, thank you so much for writing this book. I was, as the other commentators, I was really delighted to read it. Also, the good thing about these events is that you're actually forced to read it, and that was a pleasure. So let me explain why I found it refreshing and in a way provocative. Well, first, the book, in your book, you look at the system of competition law enforcement, and then you take a step back and you think, well, how can the functioning of that system be furthered? How can it be improved? And that's, to some extent, that's novel. That's new, because the more traditional way of looking at competition law enforcement is to look at the existing instruments, the existing enforcement mechanisms, and then to ask yourself, well, what can we do with this particular instrument, and how can it be applied more effectively? But then you take a much more radical approach, and I think that's very interesting. Second point why I find it refreshing is that much of the debate about competition law enforcement is framed in terms of, well, do we need antitrust enforcement or do we need regulation? And I think, as you just mentioned yourself, the discussion about this new methodology, this new way of enforcing, sort of bridges the gap a little bit between those two extreme positions. Now, personally, I'm not super keen on regulation, and hopefully we can discuss the DMA, which I think is in many ways, debatable. I'm not particularly happy about the way the Commission is going about regulating the platform-based industries. But again, your way of looking at competition law enforcement allows us to have a more nuanced view of what needs to be done in areas where we think that there is a problem. The third point is, in many ways, your book is a plea for diversity, and I'm very much in favor of diversity. I think it's very appropriate to position the problem in light of the strategic uncertainty, the polyarchic nature of the collaboration, the universe in which competition agencies are operating, and in many ways, discretion, flexibility, tailor-made solutions are likely to bring about the most efficient, economically efficient result, even if they go beyond what some agencies would think is appropriate. You made me think about South Africa, where, as we know, the test for anti-competitive mergers is not only whether they are likely to increase prices, but also whether they are having a negative impact on labor relations and more, let's say, social considerations, I don't think that anyone would seriously say that that is a bad system. Besides, it's reasonably predictable, and so I don't think that many people would have an issue with it. Of course, you can have an issue with, well, you know, should this be the case under competition law or not? But I think that's a different question. Now, whether a reader, Yane, of your book would appreciate your conclusions depends, of course, a little bit on where that reader comes from and what the perspective is. And so I just wanted to share with you very briefly how I approached the book. As Jonathan and others just mentioned, I'm on the dark side. I defend companies against competition agencies who take wrong decisions, and I encourage companies to complain to other agencies, hoping that those agencies will be interested in taking action against other companies. So that may be the dark side, and as Rupprecht already mentioned, I like a predictable, rational, economic framework that tells me and clients whether what they do is right or wrong. Now, the business community is sometimes a little radical in its request for certainty, because it's a little disingenuous. I mean, I think at the bottom, yes, competition law must be predictable. Jonathan, you mentioned, well, maybe we should accept that there's some uncertainty, but then we should better explain how the rules can be applied differently in different situations. I like that idea, but I'm not sure if it actually gets us to, you know, the ideal state of predictability for companies. Now, the second point is that even though I'm not an academic, I do believe in the international competition law enforcement system. It is important. It generates economic welfare. Many people are much better off with competition law, and you know, ICN, OECD, and many other international organizations have done a lot to bring agencies in other sometimes in lesser developed areas to enforce competition law to the benefit of their people. The third point is that I appreciate that there's a need for evolution, and the question is, well, how do you get to that point? So I think, well, being on the dark side, that leaves me at the place where I'm hoping for predictability, transparency, rationality, a rational approach, but also due process. By the way, I like very strict due process principles that bind agencies and controls the power that they have. The idea of structured experiments is a very attractive one. Siún is there, and I think her agency is one agency that is experimenting in a way, especially in the sustainability field, and that has prompted a European-wide discussion about how do we evaluate sustainability initiatives. I think that's a very, very helpful approach and a very courageous approach by the Dutch agency. The need for structured experiments goes beyond the ICN, and the problem with the ICN, and Yane, that's to some extent you reflect that in your book. The problem with ICN is that, you know, it's geared towards convergence, and some would say, well, it's dominated by the larger, more established agencies, and so it's not an ideal universe for experiments. So I like the idea, with the proviso that there must be some predictability. Now, the one reservation I have is, what happens if experiments go wrong? And there are two assumptions, I think, implicit in some assumptions. One is, we trust agencies to do the right thing. We trust them to take decisions that promote economic welfare. That's one thing. And the other thing is, we trust them to be receptive to what other agencies will tell them. And that may not always be the case. And I just wanted to share one or two examples where I think agencies simply took the wrong decision. And the one is Saudi Arabia, where a couple of years ago, the Saudi Arabian agencies took wrong decisions in relation to vertical agreements. They treated them as cartel agreements. It was wrong. Every other agency would have taken the view, look, this is a potentially pro-competitive agreement. The Saudi agency, for whatever reason, took the decision, no, this is wrong, and I'm going to impose fines. I think the European Commission intervened behind the scene, but it didn't change anything. Another example is Georgia, the country Georgia, which took a very debatable decision in relation to ports. And the company involved was Maersk, and the issue was about the expansion of a container terminal. Very problematic interpretation of the equivalent of Article 102. Now, what do we do about, and that's my question, Yane, for you, what do we do when experiments are wrong? Is there enough discipline in the system to make sure that that is somehow, corrected? And it doesn't really go to legal certainty, but it goes to how do you create a system that promotes optimally economically efficient decisions. And I'm not entirely certain whether if you give too much power to agencies to experiment, whether that always creates an optimal outcome. I have a lot of other things because, again, I thought the book was really interesting. I also would like to briefly comment on others, but I'm going to do that later. And I hope I have not taken too much time. Thank you.
That's perfect. Thank you very much.
Yep.
I mean, it's interesting to see how certain themes keep coming back. The relationship between scientific experimentation and experimentalist regulation or experimentalist governance, the relationship between flexibility and accommodation of diversity on the one hand, and demand for certainty and predictability, especially from the perspective of firms. And it was nice that you also brought in the international dimension, which is an important issue addressed in Yane's book. So Yane, let me ask you just to respond briefly. You can't touch on all of the points, pick out a few of the most important ones, and we'll have an opportunity to circle around. And in the meantime, I'd like to ask people in the audience, especially in the virtual audience, but also in the room, to just indicate by putting up your virtual hand whether you would like to come in and pose a question or make a comment. And after Yane has spoken, I'll start to bring in the audience, and then eventually we'll come back also to the commentators to give them a further word. So Yane.
Okay, so I'm really very, very grateful. I have about 3 pages of notes from everybody's comments, so that just proves that everybody has in fact engaged with the arguments in the book. So I'll try to kind of reformulate a number of the questions in some kind of a logical sequence as much as I can, so that I can address as many of the comments as were made. And I'll start first with Siún's comment about commitments. And I do that because, I mean, you would really see from the book that I think that as an enforcement technique, commitments basically really would be, in a certain sense, the centerpiece of an experimentalist evolution of competition law under conditions of radical uncertainty. And so in that context, I actually am quite glad, Siún, that you say that you are uncomfortable with the idea that they are a negotiated settlement, because I think that that basically is the common view about what a commitment decision is. And I think that it only tells part of the story, not just because there is asymmetries on both sides. So, the authority has more power in theory, hierarchically, but it has less information. And so the question is that, there is a kind of, give and take between the two actors. But there is a second reason why I think it's not a settlement, and that is because, when you look at a lot of the commitment decisions, and this is where Paul Nihoul's point, comes in about, we kind of at some point have to take a final decision, which in commitments in a way is delayed precisely because there is an opportunity for the commitments to be amended as the situation in the market changes. And so what that means is that it gives you an experiment of sorts, but I'll come back to that, where you are studying the effects as the remedy is being implemented, and you actually have the possibility to, in fact, alter the remedy if you deem that the market conditions have changed, or if you deem that the remedy is not satisfying the objectives that you were trying to achieve. Now, compare that to something that sort of, has become a little popular to talk about lately, which sort of looks experimentalist but isn't, which is ex post evaluations. Okay, and really, Paul Nihoul really made the point about, well, we rarely do this in competition law. Everybody's sort of, now onto this, and they're saying, well, maybe we can learn from ex post, evaluations. And maybe we can, but then we're learning about the past, and we're learning about markets that are different from the ones that we have to perhaps regulate in the future. And the extent to which that learning will be applicable to these other contexts, I mean, you're still better off doing it than not doing it. But it may be that under conditions of uncertainty, you need to be doing the learning as you are regulating or as you are implementing a remedy. Which again is what a kind of commitments-based, remedy allows you to do, particularly if you see that almost all of them incorporate monitoring. Okay, so they incorporate first the peer review element, which includes both discussion with the entity, but also with market stakeholders about the proposed remedies. And then there is a monitoring where stakeholders can still participate. So we might say, a number of you asked this question, well, why might firms not just prefer a kind of more stable, more certain system where they know what's right and what's wrong? And I'm not surprised that most firms would say that that's what they prefer, because if you give me clear rules, I also know how to sidestep those rules most easily. And so, yes, if I am regulated, I want certainty, because certainty tells me how I get around the rules. And so, why is it that they would participate in these that I would call, experimentalist governance techniques? It's because of precisely of the give and take, and because of the possibility that they get to reformulate their business strategy in a way that attenuates some of the concerns that have been expressed. Okay, so sometimes we're not sure whether the strategy is anti-competitive or not, either in its conception or in how it's going to play out. If we can kind of remove some of your concerns, we can reformulate the strategy where we want to pursue the business case, without having to, worry about being prosecuted. So maybe there is a give and take also with the firms, which is why they want to participate. Second, about the courts. So I really am encouraged by Paul Nihoul's, comments there. And I actually tend to agree with you that the European courts, probably not by kind of, deliberate attempt to be supportive of experimentalism, have in the end been, supportive of experimentalism, in a kind of almost accidental way. And I try to point out that in the book, particularly in relation to them not doing what many other courts have done, which is to kind of, create a very strict probabilistic framework about analyzing the link between the evidence that's currently available and the likely future effects that an authority has to demonstrate. So, for example, in the Australian context, this kind of a strict link is required, and that makes it very, very difficult for the authorities to win cases, let alone to be experimentalists. And I think that here, precisely by kind of saying, well, there is some uncertainty there, you actually what you end up doing is encouraging the parties to participate in the commitments process. That's at least how I would see it. Now, my third comment relates to this idea of experiments and whether what we're doing here is something akin to scientific experiments where we're trying to kind of, identify certain general rules of causation and what makes a successful intervention and not, so that, we can kind of, have a corpus of things that are generalizable. And there is an element of this, again, in some of the newer legislative proposals that talk about sandboxes and the idea that you can kind of, let regulators work within sandboxes in order to identify and distinguish between success or failure. Now, I discuss this in the book, and I try to point to a few examples where, when you talk about competition enforcement that occurs in the context of market interactions, these are very, very complex systems that have different sorts of, inputs in different countries and even different localities. And so the idea that you can design sort of, optimal experimentation structure in which, we can identify what the causal links between success and failure are, seems to be very, very unlikely, because the circumstances, even when the problem is the same in different countries, are very, very different. And so that's why the kind of experimentalism that, I and colleagues like, Jonathan have been talking about, does not principally rely on the scientific idea of experimentalism, but it's a kind of more pragmatic idea that, we all try to solve similar problems. We implement solutions that are tailored to our local conditions. There is no attempt here to identify kind of the general conditions, the general causalities or conditions of success, but we are engaged in a peer discussion with other knowledgeable actors, such as, authorities or stakeholders that are observing all of these implementation exercises and that are asking us questions. Why did you do that? Have you thought about this? Have you thought about that? As part of the peer review process. And so the idea is that, through this kind of diversity, you are perhaps learning about certain generalizable conditions of success, but more importantly, you're improving each of the individual implementation exercises. And to that extent, I guess, going back to Rupprecht's question, and I think others had it as well, how much diversity can you really have? And that's a question to which there is no kind of, ex ante really, optimal answer. And so to that extent, the booking example might be kind of one template for saying, well, perhaps the conditions are similar in either from a legal or from a market perspective in a number of countries, that they can pursue a particular course of action, and then some others can do it differently. So that's, one way that you can proceed, but also we have to remember that, and this is something that I stress in the book as well, sometimes you might need a degree of sameness in order to be able to, pursue an experimentalist sort of, learning from difference. And so, in the book, for example, I talk about something like, the issue of the lenience program, where, there is actually some uncertainty about what kind of a lenience program best detects, cartels. But there is also a problem that when you have diversity, you might basically undermine the whole purpose of having a lenience program if everybody has the incentive to just go to one authority. So then you have to think about the kind of, that you might actually need to have some base of uniformity in order for, you to be able to test divergent approaches to the solving the same problem. And maybe I'll stop here.
Good, perfect. Excellent. So can I see some shows of hands of people who want to come in? And there was at least one person who at the very beginning seemed to have her hand up. But
might have been a mistake.
yes, it could be. But we can also kick off with people in the room.
Yeah.
I
I
don't.
have a question.
Yes, well, let's take it while people gather their forces. So if you are interested in the audience in intervening, please put up your virtual hand. You'll find a reaction button. You should be able to do that. And in the meantime, we'll start with people who are here in the physical room who are ready to make a comment. So, Kati Chair.
Yes, thank you. Thank you very much. And thank you for all the comments, which were very interesting, as well as the book, Yane. And let me come back to these final issues that you were discussing, which also links back to some of the commentators have been addressing. And maybe you have been asked the same questions, because I know that you presented the book in the ASCOLA session with Southeastern European countries. And I will take that perspective as well, where I wonder that, so in the sense how you understand experimentalism, when we talk about the possibilities, and you mentioned specifically the leniency program as one of these illustrations, to what extent are we really talking about all the members of the group? And now this is one part, I think, of the book that we have not yet addressed, the ECN network, so the European Competition Network, where I think that, just like Paul Lugard has said about the ICN, there are bigger voices. Maybe Rupprecht mentioned Germany, we are talking about the Netherlands, a few other countries, the UK is out, France, but we'll have to see what route that takes. But that's certainly not 27 member states. And I have been always wondering to what extent, the ECN as a network with 27 members, whether what we are discussing here is wonderful and it might be progressive and taking indeed enforcement towards next steps, but to what extent everybody is on board, right? And what happens when there are agencies where we talk about, and Paul Lugard was giving examples from outside of Europe, but we don't have to go outside of Europe, where an agency is not taking action at all. So we are talking about inactivity. I'm sure that maybe some of my colleagues from those countries have given examples. So that's one question, to what extent everybody is on board, and indeed this experimentalist idea, like the leniency program, sorry, to come back to that, that's typically something which in some of the new member states was completely not working when they copy-pasted it from the Commission. They really had to work very much on it, and I think up until today it's not working in many countries. So that's one point. And the other point I wanted to address, and maybe Siún can also come back to that, because you talked about, yeah, it would be lovely to have this little bubble where we are safe and we can do whatever we want. And I think there is this little bubble. We have been looking at it a lot with our group in our study, and that's this bubble of discretion of an authority, this administrative discretion, which is in many cases, as we have seen, is simply not covered by judicial review. There are many agencies and many instances where the court will not touch upon certain decisions that the competition authorities are taking. So I was wondering whether your theories and also experimentalism within that area of administrative discretion, where choices can be made I go for digital markets as priorities, or I take this case, but I don't take that case, whether that would be an area, a safe area, apparently also for the NCAs, but also for you, with many, of course, questions about legitimacy, rule of law, and how administrative law principles govern that, but where that would be also perhaps good to look into. Thank you very much. Sorry, I took a bit longer.
Before I let you respond, Yane, let me see whether there are other people who want to come in. And let me say that some of our commentators may have to leave around 5. We're going to go, if the discussion continues to be lively, we'll run past 5. But of course, anyone who has to leave, we fully understand that we said we were going until 5. So can I see any hands? I don't see hands in the virtual chat. Are there other people in the room who want to speak? Okay, so I see Jan Brulik and Giacomo Tamburi. and I'll let you both ask your questions. And I also see Paul Lugard. And Paul, do you have to leave imminently? Do you want to come in right now?
No, I'm very happy to wait. Thank you, Jonathan.
Okay, all right. So let's take Jan and Giacomo and Paul, and then maybe we give Jan a further chance to respond.
So I would like to ask about the role of national competition law in all this, because member states can, of course, have at the same time also national competition rules. What I find particularly interesting is when looking at this Facebook case that Rupprecht mentioned earlier, is that the German authority actually rather applied its national law than EU law, even though they have the explicit permission for this type of cases. So abuse of dominance cases, they can theoretically, they can interpret EU law more harshly, let's say, and for sure they can have their own national rules. So why do you think they decided to go for only their national rule? Isn't it surprising in some sense when we speak about experimentalism that they didn't experiment with EU law, they rather experimented with their national law? And then second question, that's about the role of special interests here. So to what extent is experimentalism something that allows for a greater influence of special interests? If you have given this any thought, is it maybe, does it make it more difficult for companies and other interested parties to lobby the institutions involved, because there are more of them under the experimentalist governance, more of them who actually decide on how things will be done in comparison to the situation when it's hierarchical, so there is just one central player who decides the rules of the game. So yeah, these are my two questions.
Okay, Giacomo.
Thank you. So my question, so I have one reaction to one Rupprecht's comment about the fact that in the Google decisions, the commission uses a sort of rather conventional approach to a very new problem, and whether it would be desirable that they're explicit to say it is a very new problem, and so we don't know exactly, and we're gonna. So I mean, what's your stake on, let's say, being explicit about like experimentation, or rather just not saying it but still doing it, and whether that plays a role in your analysis? And my other question is about what your framework tells us about the debates on the goals of antitrust, and specifically like the whole neo-Brandeisian movement, and whether we should abandon economic efficiency for more other ideas of what antitrust is for.
So we have some students coming in to join us. Okay, Paul Lugard, you have the floor.
Thank you. And thank you all for a really very interesting discussion. I just wanted to raise a couple of things. Thinking about the role of the court, I realized that I just noted down a number of important court judgments that have brought. They were all preliminary references, but they have been so important for the uniform application of competition law. And I was just wondering whether that, what I see as a very beneficial development, and a very, very favorable force in the development of competition law, how that role relates to experiments. I would be very reluctant if the role of the Court of Justice would somehow be compromised in that sense. The second point I wanted to make is building up on something that Kati just mentioned. what happens if agencies don't do anything? So we now have an agency that doesn't experiment, but they simply sit still. And so, you know, is there, would peer pressure also apply if these agencies don't do anything? And then maybe one comment on booking.com and the Facebook case. I think most experiments are cases where agencies expand the application or expand the prohibition of 101, 102. Now, theoretically, it's also possible that agencies also experiment by narrowing the scope of competition law. So let's assume that an agency says, look, I don't think that this conduct is called at all. And so it says, no, there's no violation here. What happens then? Final comments. I just wanted to say that I am a little skeptical that agencies will always do what we hope them to do. I mean, we think of them as rational actors, but maybe sometimes those actors are not all that rational. And I just mentioned the Saudi agency and one or two others. So I'm just a little skeptical, even though I like the idea of experimentation. I don't think that should always be to the detriment of companies. I think there should be some limit, because I don't think it's fair to expect the business community to, you know, to be the subject of experimentation, you know, again and again and again until the agency gets it right. Let me stop here.
Okay, thank you. And well, Paul Nihoul has left, but we thank him for his contribution. I see Mira Schulten has a question. What I suggest, though, since there's quite a lot already on the table, that Jana takes an opportunity to respond, and then we have one more round of questions and exchange. We also perhaps give Siún and Rupprecht a chance to come back in if they want to.
Okay, so thanks for those questions. Again, I'll try to, you know, group them around some similar themes. And one theme that emerges from all of the questions relates to the discipline on agencies, you know, both at the national level and also, you know, at the EU level. So, you know, there is necessarily some degree of skepticism, you know, that agencies will necessarily always kind of, you know, take up the opportunity that's given to them by this experimentalist structure and kind of, you know, use it to, let's say, expand the scope and of application of the European competition law. And I think that here, as good sort of, you know, competition lawyers, we should also you know, think a little bit about the counterfactual. Okay, so what is it that, you know, how is it that we usually discipline agencies, including in the exercise of their discretion? And is it that within an experimentalist framework we improve the disciplines that exist on agencies, or are they worse? Okay, so in the standard case, the disciplines on agencies and agency discretion are basically some sort of political or legislative oversight, together with judicial review. Okay, and there is a literature which would be even more familiar to you in both political science and in administrative law, about disciplines on agencies and the degree to which it's effective. And I think that, you know, my summary of that literature, which might be sort of a bit self-serving, is that it's largely hit or miss, and you know, there's no kind of, especially once regulation becomes much more technical, and as in competition law, very fact-based, so that you are not disciplining the agencies through rules, but through kind of having to look at what they actually do and how they perform their functions, then, you know, the standard disciplines on agencies are basically hit or miss. And what experimentalism brings to the table is, you know, the peer review element, which includes the peer review from other similar agencies operating in a similar field and on similar problems. And again, even if you don't have the intention of, discovering sort of, general rules of causation or generally kind of, successful practices, you have a source through which you can basically say, well, at least in comparison to such and such, here you are not intervening at all in this kind of a problem. Why is that? Now, there has to be some domestic public that's willing to take on this information, in order to bring some discipline to the agencies. But it's a much richer sort of, environment in which you can impose that kind of at least deliberative discipline by asking questions about why you're not doing anything or why you're doing this differently from what the Germans are doing and so on and so forth. And I think in that respect, whether the agencies are acting under the exercise of their discretion purely, including the discretion to evaluate facts, which in competition law is sort of very important, or whether they're acting under national law doesn't matter that much. So the German agency, in choosing to pursue Facebook under German law, might be saying, look, our rules in EU competition law haven't changed for decades. And so basically most of what we do when we're undertaking case analysis is basically fact-based analysis vis-a-vis some precedents. And we in Germany actually have tried to develop some tools about how to think about competition in these new settings. And they ease our job in doing that analysis. So it could just be the reason for choosing German law is to say there is a way to do this without kind of like just all things considered, balancing of factors and factual evidence. Now so if agencies kind of exercise their discretion in a negative way, or they don't take any action, or some of the examples that I also discuss in the cases of some of these kind of let's say recalcitrant agencies, there are two options that they have in the experimentalist framework. One is to say, look, what we're doing is actually not that offensive from a competition point of view. And I try to point to some examples where even the courts could have tried to distinguish between agencies essentially being either incompetent or captured versus doing, so the Deutsche Telekom case versus Telefonica is the example that I use, where, with similar kind of decisions, you could say, well, in one case, you're actually trying to promote infrastructure investment, which actually turns out we're now finding out in telecoms is really, really important and not something people were thinking about. In the other case, they were just sort of, either captured or they were using some sort of an outdated methodology. And if you use the peer review framework, you actually can arrive at that conclusion in a way that a court might not be able to just looking at the decision of the agency itself. Finally, well, I suppose there's two things that are on the table. One is, being explicit about experimenting and not. And I think this is quite an important point because I think that, and this has already come out in the discussion, I think that there is a reluctance in regulators and agencies to acknowledge uncertainty. And I think that there's even been sort of, research that has been done here that, discloses that there is this reluctance because it can be seen as, either being incompetent or sort of, engaging in kind of trial and error, regulation. So there is some reluctance in agencies to acknowledge that, when they decide to take a decision, that in fact, they are a bit uncertain about, their ability to effectively regulate the problem. And the question is, part of the aim of my book is to kind of, take that stigma away. I think that here, I mean, in relation to the Commission's decision in Google, I think that, what happened there is that, there were multiple rounds of commitments negotiations. There was also input from third-party stakeholders about the likely effectiveness of the commitments that had been proposed, and I think that the Commission sort of understood the full extent of the uncertainty problem. And even though they proceeded with a violation decision, the remedy I characterize as being experimentalist. And finally, on the neo-Brandeisians, this idea of that now seems to be very popular, including in policy circles in the United States, which is a kind of re-emergence of a certain type of structuralism in market analysis. Even though for me it's not always very easy to pin down what are the limiting principles on that structuralism. So I mean, if you're going to be sort of breaking companies down, how are you going to do it? What's the limit to that? And so take the Facebook example. I mean, there was a recent article in which The Guardian went around to a number of experts, including people on this oversight board that Facebook has, to see whether there was a consensus on what the problem was and what needed to be done. Now, if you look at the survey, it's about, I think, 5 people or something like that. Everybody agreed that there was a problem. But then beyond that, it was very difficult to elicit agreement either on defining exactly what the problem is, and then let's not even speak about the solutions. And so let's say that we are a kind of that we're a sort of new Brandeis and say, okay, a structural approach is needed here. So what do? Do we create 10 new companies, each of which is behaving in the same way? Where the market might tend to a single supplier eventually anyway, is that a solution to the problem, or does it just sort of basically multiply the problem? Now, if you want to avoid this after your breakup, you would need to basically create some kind of a monitoring and oversight regime that basically tries to define the nature of the problems that we're trying to solve. You want to target some measures, on how to solve those problems, and so you can see how that infrastructure will basically converge on some idea of experimentalism, because you're not just basically saying once we have 10 companies, the market will sort itself out. You still have to engage in some sort of monitoring and review. So I think that, if you, unless you believe that simply having multiple players improves things, which I just am very, very doubtful, you might end up in experimentalism anyway. And so I'll stop there.
Yeah, thanks, Jan. I had been wanting to ask you about the neo-Brandeisians or the American debate as well. And one way to think about this is that if you don't have experimentalism, as we do in Europe, then you might wind up with this very, relatively crude insistence on structural rather than behavioral remedies. And there is a further irony that Brandeis himself, on the best interpretations, see the book by Gerald Burke, was himself an experimentalist who believed in regulated competition through monitoring and dialogue with industry actors and associations. But let me give the floor to Mira Schulten, who's been patiently waiting, and then I'd like to ask Siún if she wants to intervene again.
Yeah, thank you very much. It's a very interesting discussion. I have a short question or perhaps an idea. I haven't read the book, so I don't know if you have addressed it there, or perhaps you have ideas. But while listening today to all the presentations, I had a feeling that, well, we have a problem with the legal certainty, or how to ensure it, or how to promote it, because it's kind of something what the regulators would like to have, and private actors as well. So then I thought, to what extent perhaps it could be possible, or perhaps already is in your book, I don't know, to have kind of a distinction, I don't know, to make a typology of certain types of provisions that we can have in regulation, I would just say ex ante, and also to be enhanced, exposed, to create this certainty. So basically, if you see it as a formula, we have institutional provisions, we have regulatory goals, we have values, principles of work, principle of legality, and certainly, etc. And then enforcement mechanism, etc. And then to what extent we could perhaps create a sort of EU competition theory that we say, well, certain types of provisions, certain things could be more certain and could be more uniform, and others have to be uncertain or have to be dealt with at a lower level. And there we have more discretion. I don't know if you have thought about it, but just this is the idea that pumped up in my mind when I was listening to all the talks. Thanks.
Sure, you want to come in?
Yeah, just with a few thoughts on what other people have said, really. I was thinking about, how do you create this space where you have more freedom for experimentation, and in a way, this has happened in particular areas in Dutch law, where we looked maybe at the healthcare sector, at the sustainability problem, where we say, okay, we're not in a hardcore situation, but we're in a situation where we see a market not working perfectly. Let's look at it more closely. And then you create a certain amount of certainty by saying we won't fine. You go to the firms and you say, we won't fine you. You cut out then a lot of your judicial review risk. And although I don't think that's actually the main concern of the authority, it's the authority is usually quite keen on judicial reviews. It's helpful, gives more certainty. But it takes away the reluctance of the companies to share information with you. And so that's where the advantage to it is. And that's how I think you can create some space by saying, okay, within this framework, we won't fine you, come and talk to us, and we'll see what we can do. But even there, you are restricted. So you're restricted by your obligations under community law in terms of keeping it national, which comes back to maybe what your question was. And that is, of course, if you're operating under your national law, then you're not subject to Regulation 1/2003 with all the obligations that are written in that regulation, which may give you a certain amount of freedom. Just something about what you've said, some countries having more possibilities than others for all sorts of reasons. I still think, and that's what I like about Chapter 5, is that international sphere is very important, because even if the larger states and the larger agencies have a lot of advantages in terms of what they can do, the smaller agencies can hitch a lift, they can learn, they have access to more information than they would otherwise have. And sometimes they quite like a system of peer review, which makes it obvious to their government what they can and can't do and what other countries can do. And these reports and these surveys, in which, as you said, in the ICN case, they may not have actively participated, it's still there. So the day their government comes in and says, we're thinking of criminalizing cartel laws, they have something they can take off the shelf and say, oh, well, look, Ireland tried it and it didn't really work, or whatever. They have a basis of information they can use, which to their advantage. So more information, I think, is always good.
Before I'd like to respond, Yane, one last point. We've talked a lot about this issue of legal certainty, and I'm reminded of this famous article by John Braithwaite, which is now 20 years old, on rules and principles, the theory of legal certainty, where he in essence argues that making rules more and more precise and specific, especially when they interact with one another, and especially against the background of an uncertain or rapidly changing world, actually produces unanticipated consequences, which themselves are a very important source of uncertainty, not least for firms. And he discusses that, the solution to this, in terms of various combinations of binding rules and non-binding principles. But one could also think about experimentalism as a solution to that. You do have something to say in the context of a book about simple rules for a complex world in your own book. So maybe I can ask you to address that kind of question about what do we really mean by legal certainty, and what is actually attainable, and how experimentalism might weigh up on that criterion as opposed to other more conventional approaches.
Okay, so I'll take Mira and Siún's comments together, because I think that they go to a set of common issues. I think that, I think that Mira, you kind of very nicely sort of, point out, one of the ways in which we can frame the debate, which is, perhaps there is room for, some degree of uniformity and convergence in certain areas, and then a kind of, a residual area in which there is sort of, room for experimentation. And then, Siún kind of was talking about kind of creating these safe spaces for experimentation. And I think, that's a kind of reasonable, that's a reasonable way to think about it, about, how to kind of make this manageable. But there is a sort of word of caution there as well. So for instance, you might say, okay, well, there is a certain area of certainty, and maybe, in there we can just basically all follow the same rules, because there is not much to kind of, there's no reason for experimentation. And so in antitrust, the typical thing that people would talk about would be sort of, something like cartels. We all know that they are, bad, that they're anti-competitive, they're the evil of antitrust. Okay, well, that's one area where we can kind of, have some commonality. And then, in these more complex things, maybe we need to allow agencies to experiment. And that's fair enough, and that might be kind of like, that might be fine, so long as it doesn't obscure the fact that even in areas where you think that, you're not facing a lot of uncertainty can creep in. And we see that in the cartel space already, once we kind of, start talking about these algorithmic forms of collusion and so on and so forth. And how best to either sort of identify that there is collusion, and how to remedy it. And so you can see that in a dynamic environment, the areas where you can just kind of sit comfortably and say we worked that problem out, and we can just sort of sit back and rely on our own rules, might be risky. And so you might actually need to leave the conversation open even there, so that somebody can say, well, now we're faced with an uncertainty problem, and we might need to actually kind of re-engage the experimentalist apparatus, if you want, in that area as well. I think, this idea of thinking about how to create the space for, trying out new things in a dialogic way, such as, for example, saying, we won't fine, that's one way that you can do it. I guess the question, and that also goes back to this sandboxing idea, where you say, okay, well, we'll let you kind of innovate here without, fining you. That can work, but you have to also be cautious about who is participating in the conversation. Because if it's just the authority and the entities who are, playing in the sandbox, it may be that you're not so sensitive about the potential effects that is having. And so if you are engaged in experimentalist monitoring, you must make sure that the potentially affected parties are part of the conversation, because otherwise the risk of capture is too high. And so that's one of the things that I'm a little bit worried about in this kind of sandboxing discourse about, exactly what's envisaged there. I actually think that there is nothing wrong with, now that there is a certain level of convergence in the national laws with the European framework, that actually countries are experimenting with kind of reformulating their provisions in a way that might be a bit more sensitive to current problems. And I can see that Kati is sort of, skeptical, and I know why. But at least it's making it explicit that you're doing something different. And then somebody will have to kind of pay the costs for or enjoy the benefits of having done that. And then finally, on legal certainty, I actually had good ideas kind of, I suppose, recur over time. I was not aware of John Braithwaite's paper, but he basically touches on an issue that I touch on as well, based on some more recent work about what kind of a regulatory regime, a legal and regulatory regime you need for a very complex and dynamic world. And one option, precisely as John Braithwaite points out in the paper you cite, I guess, is that you try to develop a legal regime that's ever more complex because it tries to capture an ever more different and complex set of circumstances. So you want to have a rule for each possible situation that arises. That kind of further specialization and complexity in the legal regime, actually, as Pure and Schrank show in their work on root cause regulation, actually leaves the companies at the mercy of discretion, because there are conflicting rules that apply in the specific situation from different regulatory regimes. And then there is a residual discretion about which rule is going to be applied in that particular circumstance when you have a very complex system of specific legal rules. In that case, even if you are a company, you might prefer actually to know what each of the regulatory regimes is trying to achieve and have some degree of ownership of kind of how you go about doing that, rather than to be subject to these kind of completely possibly conflicting rules and the discretion of how they're going to be applied, or which one is going to be applied to you in the specific case. This brings me back a little bit to a discussion that I guess we had in the aftermath of the financial crisis, where people talked about, for instance, principles-based regulation and the failure of principles-based regulation. And principles-based regulation was the idea that the authorities don't specify all of the rules that are out there to be achieved, but they specify a set of principles that you need to internally promote through your kind of management-based systems of compliance. Now that can look experimentalist, because you're saying we have some goals that you need to promote. We give you the discretion about how you promote those goals. But the problem was that basically all both agencies, if you look at it at the European level, but also companies, essentially implemented the same kinds of both risk control techniques and business strategies, and so then you were basically stuck in a regulatory monoculture, which exacerbated systemic risks. And that goes back to your point, Giacomo, that sometimes actually kind of being conscious about the fact that what you want is experimentation and learning from diverse experiences that can be helpful, because it can show you that something that looks like experimentalism, in fact, is not working in an experimentalist way. So maybe I'll stop there.
Yeah, that's a good place to start. It would open up to a discussion of the role of guidance provided by agencies to, well, at the European level, also to national authorities and to firms, and a kind of hierarchy, if you like, of norms and rules at different levels of specificity, with the ones that are most granular and concrete being the most easily revisable, because precisely they are formally non-binding guidance. And there is a whole discussion about that, also a very interesting piece in the American context by Chuck Sable and one of his colleagues in called the Uncertain Future of Administrative Law. That's in a volume edited by Mark Tushnet on the future of American administrative law, published in the journal Daedalus. But I think at this point, we've tried everybody's patience. I want to thank Jana, I want to thank Siún, I want to thank the other discussants who've had to leave, and the very patient audience online, but also here in the room. And I'm sure this discussion will continue. And those of you who haven't read Jana's book, once again, I urge you to read it.